Hello and welcome to the Beresford Booth Weekly Webinar. My name is Amanda Gamble, and this week we are speaking with Judge Steve Rosen about the Uniform Family Law Arbitration Act. Before we jump in, I would first like to share a bit about our esteemed guest. Judge Steve Rosen obtained his bachelor's degree from the University of Washington, earning a degree in economics. After attending law school at the University of Minnesota, he became a prosecutor and eventually an assistant attorney general. He then opened his own firm, which focused on criminal defense, real estate matters, and class action lawsuits. He became a part-time judge in 2007 and a full-time judge in 2010. He retired from King County Superior Court in 2023 and now runs Rosen ADR. And outside of work, he enjoys spending time with his wife and children. Thank you, Judge Rosen, for being here today and discussing the Uniform Family Law Arbitration Act with me.
Thanks for having me.
Throughout this presentation, for purposes of brevity, we may be referring to the Uniform Family Law Arbitration Act as either UFLAA or the Act for short. So let's get started. For some of our viewers, you may not be familiar with the term arbitration. For those viewers that act as an arbitrator or are a practitioner and are familiar with the term, give us just a moment while we answer this question. So Judge Rosen, to start us off, what is arbitration?
So arbitration is like a trial. The difference is that the parties choose who the decision maker is. In a trial, the decision maker is a judge. In an arbitration, the decision maker is the arbitrator chosen by the parties, paid by the parties to make a decision in a case.
Thank you for that explanation. Arbitration can be a useful tool, and this is why in 2005, the Washington State Legislature enacted the Uniform Arbitration Act under RCW 704A. However, recently, the legislature understood the need for some changes to the arbitration rules for family law matters. That is where we get the Uniform Family Law Arbitration Act, or RCW 2614. Can you share the intended purpose of the Uniform Family Law Arbitration Act?
I'm not sure that I can. I can give you some hypotheticals or some inferences maybe as to why this passed. The legislature is a body that does what it does, and sometimes it's hard to discern, even if you talk to a legislator, why they did what they did, because it's a big body of people. But the idea is that there is a group of people that enacted or sort of suggested a model law. That is a law that would be the same in every state so that it's easy for people to understand. And as judges decide certain issues under that law, it could be applied nationally, that decision. And so the Uniform Model Law people proposed this act, the Uniform Family Law Arbitration Act. And Washington is, I think, the sixth state. It's either the fifth or the sixth state to enact it. And the idea is to have a uniform process for arbitrations in family law that's fairly uniform across the country. It does a couple of things that are new and a lot of things that are somewhat redundant of the old act, the General Arbitration Act. Some of the new things have to do with recordings of the proceedings, trainings for the arbitrator, qualifications for the arbitrator, and also some protections for domestic violence victims.
And then when does this law go into effect?
January 2024.
And will this apply to Arbitration Act agreements that predate this law?
So sort of. There's a specific section in the act that says that if you have an arbitration agreement that was signed before the act becomes effective, before its effective date, then the parties can choose to use the procedures of the act, but don't have to. And if they want to use it, they have to sort of sign an agreement that says we agree to use the new act.
Good information for practitioners to keep in mind when they're scheduling arbitrations for next year or they already have them scheduled. So under the UFLAA, what relief can an arbitrator offer litigants?
So that's a great question, because the Act has a list of things that an arbitrator can't do and a list of things that the arbitrator can do. So the arbitrator can make decisions, can issue temporary orders in a family law proceeding. So that would be, a divorce is filed and the family needs some immediate guidance on finances or where the children are going to reside, and see each parent how many hours per day or per week or whatever it is. So the arbitrator can specifically do that. And generally make decisions for the family. The arbitrator can make a binding decision, a permanent decision that sort of, I don't want to say that it can't be appealed, but that it would be very, very hard to appeal for financial issues, and then can make decisions for things related to children, like custody time and child support, that are a little bit less binding, a little bit less final.
And so, of course, there are limits to the Act. So what specifically does the Act say that the arbitrator cannot do?
Well, the list is long. I would encourage anybody who's interested in this to go look at it, because I can't cover everything. But the arbitrator can't actually grant a divorce. The arbitrator can decide these are the terms of the divorce, but then a judge has to sign off on it. The arbitrator can't terminate a parent's rights. They can't issue domestic violence protection orders. Those are the main ones, but there's actually quite a long list of things that are specifically excluded.
And as many of our viewers are aware, in order to memorialize the fact that parties would like to arbitrate their family law dispute, they sign an agreement to arbitrate. And this typically outlines the rules that will govern that arbitration. Under the Act, what provisions must be included in the agreement?
There has to be a recording of the agreement, meaning it has to be either in writing, which is probably the way it will almost always be done, but it could be done electronically, like on a recorded Zoom call like we're on right now. There needs to be a recitation of what the terms are, how the arbitration will proceed, those sorts of things.
And how do the parties select an arbitrator? And are there certain qualifications or requirements that an arbitrator must possess?
That's a great question. And the answer is sort of. The Act has new information, or I don't want to call them requirements. I'm not quite sure what the right word is, but there are new qualifications listed in the Act for arbitrators. Those are that the arbitrator has to have 5 years of experience as a lawyer. 50% of those 5 years must have been experience with family law, or the arbitrator must be a retired judge, a commissioner, or pro tem judge. Also, every year, the arbitrators must have 7 years of specific training in things like family development, how child's develop, domestic violence, those sorts of things. The reason that I equivocated when you asked is because those requirements are waivable by people who enter into arbitrations. So the parties can say in a written agreement, we understand that these are the requirements of the Arbitration Act, but we are going to waive them, and that's valid, and that's something that can be waived. And as for the other part of your question is how do they find the arbitrator? That's a difficult question, because there's not a uniform way that arbitrators are located. Obviously, there's the internet. There are referrals from lawyers. There are panels of groups that do this sort of work. And then there are a lot of individuals, retired commissioners, judges, and lawyers around at least the Puget Sound area who do this sort of work.
And does the Act explain how, or is there a database that's going to be that people can find to locate to find out if their arbitrator has the qualifications listed?
No, that's also a great question, because you would think if there's sort of a pseudo licensure, right? You have to meet these requirements to do this certain government sanctioned thing, that then there would be a list of the people who have met those requirements. But to my knowledge, there is no such list. It's just going to be self-reported, I suppose, honor system based. I'm not sure. I have talked to a number of other people in the industry, and some are considering making a standard part of their contract, meaning the arbitrator might offer the parties a contract for arbitration that says, even though I'm qualified and I believe I meet these requirements of the Act, you're waiving the right to have someone meet these qualifications in case I'm not correct and I don't actually meet the Act. An example would be if a lawyer has 5 or more years experience, but maybe in one of those years they didn't handle family law cases, but in the other years they handled 70% family law cases, or it's difficult, as you know, you're a practicing lawyer, exactly what percent of your cases involve child custody is not something that's easy to determine. So it could be that we end up with that issue or those requirements being waived a lot.
And as you'd previously stated, the Act now requires all arbitrations that deal with child-related disputes to be recorded. But are there specific provisions in the Act that govern those recordings?
There are. So to recap, a child-related dispute is anything that deals with child custody or finances related to a child, which we would call in Washington child support. So if either of those things are involved in an arbitration, then the way the statute is actually worded is that those portions of the arbitration that deal with child-related issues must be recorded. Now, practically speaking, I can't figure out how you're going to record, a witness's testimony when in one sentence they say, this is why the other parent is a good or a bad parent, and then the next sentence is about division of assets or a bank account, and then the next sentence is about child support issues and the bank account affecting it. I think what's going to happen in real life is that the whole thing is just going to get recorded. The Act indicates that it must be recorded. It doesn't give specifics on exactly how. I believe you could record that with a stenographer. You could probably record it on a tape recorder, and probably the most common way that it could be recorded is with an electronic recording like we're using right now. Probably the most prevalent way to record will be a virtual video conferencing based arbitration where everything is recorded. One question that's unanswered is, when there is a recording now, we have a lot of computer technology, some people call it AI, that can transcribe proceedings or verbal conversations that happen over video conferencing, and can that be used? And that's an unanswered question. I personally don't think that that's a great idea. Those systems are quite amazing, but they're generally regarded by the legal profession as not quite accurate enough to be reliable as a record of what happened. So I suspect we'll be left with some sort of audio recording where you can replay the people's voices who were on the arbitration.
And does the Act provide guidelines on how long people are to keep these recordings?
There's no guidelines that I'm aware of on this. And I think that that's going to be something that practitioners and parties should be aware of and think about as they engage an arbitrator. And arbitrators should think about as they agree to take on these cases. The files from these hearings can be very long, the computer files, if you're recording it electronically. The video files and the audio files together are really, really big if you're talking about multi-day arbitration. So who's going to store them? Who's going to pay for them to be stored, and for how long? I would suggest that that's better discussed and probably put into a written document up front than after the fact. So one of the things that also definitely should be considered is what's the period of the appeal or request for reconsideration or a motion to vacate. So I suspect most people will want somebody to maintain those recordings for at least a year, if not a little bit longer.
And thoughtfully, the Act has provisions that are meant to protect victims of domestic violence. In what ways does the Act endeavor to protect victims of domestic violence?
So this is the one main, not the one main area, it's one of the main areas that is different from the previous Arbitration Act. So under the new Act, if somebody has a domestic violence protection order, so you can imagine a husband and a wife, and they're splitting up because of a domestic violence incident, and one of them has a protection order against the other, that case cannot go to arbitration unless both parties essentially in writing say they want to go to arbitration, and then they go to court and get a judge to say this is a good idea and there are specific procedures in place to protect the protected person in the protection order from harassment and physical violence, those sorts of things. That would apply, though, not only to people who have a protection order protecting them from the other party, but also someone who gets a protection order in the middle of a case, or when an arbitrator just picks up on their own that there is a significant safety risk involved in a case. In any of those scenarios, again, everything stops or is stayed, and then the parties have to go to court and get the court's blessing that they can continue with the arbitration.
And so after the parties arbitrate and they've received a decision, what must a party do to ensure that the arbitration award is enforceable?
So the procedure, for those of you who don't work in this area a lot, is that there will be an arbitration where somebody like me makes a decision. The custody is this, or the child support is that, or whatever it will be. And then I write down the decision and I sign it and I send it to the parties. But I'm not a judge anymore, so I don't have any special power to sign something and make it become effective or the law. So that becomes effective once the parties, or one of the parties, or both of the parties, take it to a judge and have the judge sign it and make it an official court order. So that step is still necessary.
Okay, so that's going to require a motion in Superior Court.
Well, we're not totally sure how it's going to work out yet because it hasn't even taken effect. It'll take some action in Superior Court. I think, practically speaking, my experience is that when an arbitrator makes a decision, the vast majority of the time, but not all of it, the parties accept that and say, okay, this is a decision, we're not appealing it, we're not challenging it. And so in that scenario, the parties could present it as an agreed order to a judge or a commissioner to sign, and that process could happen fairly quickly. If, on the other hand, it's contested, meaning that somebody wanted to take the arbitrator's decision and say it's not right, or it should be revised or changed or vacated or appealed, that process could get much more complicated, more expensive, and could cause a pretty significant delay in the order becoming effective.
And so what is the time frame for a party to confirm an award?
So if it's not agreed, meaning if one side says we don't agree with the arbitrator's decision and we're going to file a motion to undo it one way or another, then it's 90 days. So if, for example, the husband wanted to appeal and the wife wanted to get it confirmed, the wife would have to wait 90 days to see if that appeal is filed before a judge could sign off on it. But if the husband and the wife agreed, then the judge could sign off theoretically the next day.
And is a party permitted to appeal the confirmation or the denial to confirm an award?
Meaning the arbitrator's decision to Superior Court?
No, could a party appeal if a court decides to not confirm or to confirm the award?
Oh, I believe so, although I have to admit I haven't looked at that specifically, but generally whatever a Superior Court judge does can be affirmed or overruled by a Court of Appeals. And I think that the last point has the last question has a really important point in it. That if you go to arbitration and the parties don't agree, you're looking at a 3-month minimum delay, 90 days, until it can become confirmed and become effective. That's a really long time with an automatic delay. And during that 90 days, if some sort of motion is filed, it will certainly be longer than 90 days.
But as a practical note, the parties can, in their arbitration agreements, from the outset agree that they, no matter what's going to happen after the arbitration award is received, they can agree that they're going to follow it in that interim.
I would think so, yes. You and I talked about that previously offline. I think that's probably allowed, but it's not tested. You know, it's a new law and that scenario has not yet arisen, so we don't know for sure. But that's what I would encourage parties to do until we hear from the courts that that's not okay. It makes sense.
So now parties, they can seek a reconsideration to the arbitrator directly for all or a portion of the award if they agree or disagree with it, or believe it was incorrectly determined. And so that reconsideration period, is that also a 90-day period, or is that a shorter period?
No, I believe that's 30 days, and there's some specific criteria under the Act that are really actually fairly specific about what you can ask for those sorts of reconsiderations on.
And so then if after that 30-day period, then you can is that 90-day period told? Does it start after you receive your reconsideration award?
So if the arbitrator, if there's a motion to reconsider and then the arbitrator makes a decision on the reconsideration, so that process could take much more than 30 days because the party has 30 days to file it. Then there can be briefing. Then the arbitrator makes a decision. That could happen at the 30-day mark. It could happen at the 60 or even the 90-day mark. Then once that decision is issued, then there's another 90 days if things are disputed until a court can confirm it. So you could get to a very, very, very long period of time. I could honestly see something that's contested taking 6 months or more to get confirmed.
And just as another practical matter, in your opinion, do you think that's something that parties can address in their arbitration agreements as well? The reconsideration period, as long as it complies with the law?
I don't know. I mean, that's a great question. What do you think?
I think as a practitioner that we would be able to put that into an agreement, so long as everybody, I think as long as it doesn't conflict with what the law states, there would be room for us to negotiate what that period looks like. And if we're following the arbitration award, and I think there could be an avenue too, if there's something so egregious, a person could file some sort of emergency motion with Superior Court to have it addressed if an arbitrator just completely got something wrong.
Yeah, I think that probably depends on the severity, but I agree with you. If something is incredibly wrong, and courts are very, very protective of children. And so if there's something going on that either can't be undone, like one party's withdrawing $1 million from an account, you can go to court in King County and go to the ex parte department and get some sort of injunction. If there's something that's potentially harming a child, you could probably get something done fairly immediately. But the base question, can you modify the deadlines or the time limits on these things, to me is an open question, right? It might be that you can, and personally I would like that that the law say that you can modify them by agreement, but it's also possible that the courts will say that you can't do that. And so we just don't know the answer. I also, this is, the legislature gets to decide what the law is, but I don't believe personally that the timeframes listed in the act are very, I'll just be frank, I think they're too long. If you go to court and you have a decision by a judge, you have 10 days to file a motion to reconsider, and then you have 30 days to file an appeal. Why are these provisions so much longer? That doesn't make a lot of sense to me. I would rather see finality in family law cases rather than the people choosing arbitration, taking the load off of a very busy court, getting choice in who their arbitrator is. Those are all positive things. But then they're going to be faced with the other side of the scale when they're thinking about arbitration is, boy, I could have this become unenforceable for a very, very long time, even if I'm ultimately found to be correct.
Yeah, I also think it's going to take counties entering some local court rules to kind of clean up some of this as well, which we've seen with revisions and reconsiderations, and where you're going to be filing these motions and how you're going to be asking your trial judge to review these or confirm them.
Certainly, there's a lot of unknowns, right? The law hasn't taken effect yet, so hopefully some local rules will pop up. But I looked today and actually talked to a judge in King County about where to file certain motions under the new act. For example, we talked about the domestic violence issue, right? The parties have to go to court, even if they agree, and get the court's blessing to go to arbitration if there's a domestic violence issue or a protection order, that sort of thing. And the question I asked is, where do they go to court? Do they go see a commissioner, or do they go see their assigned judge, or do they go to the family law judge or the chief family law judge? And I haven't got a solid answer. It could be that there's one that I'm missing and the judge I talked to is missing. It could be that just hasn't been sort of codified in a court rule yet because it's brand new, and hopefully it will be by January. Hopefully by the time someone's watching this, there will be a new set of rules or procedures on this. But my take on it is the default is everything that is not specifically stated in the rule to go to a judge goes to a commissioner. And since this is not in the rule, I think you're within your right to send it to a commissioner. I don't know if that will continue to be the case once rules come down, but that's also not super clear. So there's a lot of unknowns still that have to be worked out.
Right. Something we do know is, and at least partially listed in the act is, what protections does an arbitrator have? Do they have the same protections as a judge would from civil liability?
Yeah, finally a softball. I like it. Thank you. Yeah, the answer is yes, right? It's going to become very, very hard to sue the arbitrator in one of these proceedings. Basically, they have the same immunity that a judge would have, which is pretty significant immunity. It's not quite absolute, but it's pretty close.
Well, I'm out of questions. I think that we've covered pretty much the entire act. Is there anything that you can think of that you would want either a practitioner, an arbitrator, or even just a layperson that is going to arbitration to know?
Yeah, a couple of thoughts come to mind. I think your arbitration agreements between the parties and the arbitrator are going to become more important than they already are. They are important now. They're going to be more important in January. You need to put in things like what's the procedure that the arbitration and the parties are going to follow if something happens, if there's a domestic violence incident. What's the procedure that's going to happen if the arbitrator becomes unavailable? Are the parties agreeing to arbitrate temporary orders? Does that mean the initial temporary orders or all orders before the final orders? And then are the parties going to agree to have the arbitrator make decisions on the final orders as well or not? I mean, there's a lot of ways to sort of divide that responsibility up between the arbitrator and the court. How will de novo review look? So de novo review is a fancy way of saying an appeal from the arbitrator to the court. So the act says that if there is an appeal to the court on a child-related issue, again, custody or child support, the judge doesn't just decide if the arbitrator makes an error. The judge also makes a decision on whether or not the decision was in the best interest of the child or the children. And so there will be cases where the one party is not necessarily saying that the arbitrator even got it wrong, but they can say this is not in the child's best interests. It probably will also say it's wrong, but you never know. And then the court has to engage in an analysis of was this decision in the child's best interest, and how does the court go through that analysis? Do they look at all the documents that the arbitrator looked at? Do they listen to all the testimony? Will there be new testimony? De novo means anew. And so before the act, as we are sitting here today, it's been very undefined already. Sometimes when I was a judge and I heard them, the parties would agree there'd be no new testimony, but there was no recording under the old or the current act. So the parties would say, just read the decision and read the records and make up your mind as a judge if this is in the child's best interest or not, or if there was an error. Sometimes they would come in front of me and say there will be new testimony, but they would agree to limit the testimony. Sometimes one side would say, no, I want a full new trial. So my suggestion is, because those issues can be very significant, they could cost a lot just to litigate. And then if the court decided that there would be a significant new trial, it'd be much better to know that going into the arbitration than waiting till afterwards for an appeal. Again, the place to put that is in the arbitration agreement. The parties agree, for example, that any review by the court will be limited to the transcript of the records, the transcript of the proceedings and the records, or whatever else you agree to. So lots of little things to think about in that arbitration agreement.
Certainly. Yeah, I think as a practitioner, I agree that the arbitration agreements are certainly going to become something that are going to be very important, what we include in them and how we word everything, and not just the process of arbitration, but after, because I agree. I don't think the act has answered all of those questions.
Yeah, and then I think because of the recording, which is brand new, you have to also take a cost-benefit analysis to the cost of transcribing the proceeding if there is some sort of appeal, which those recordings can get fairly expensive. But everything is expensive, so it's a cost-benefit, but it's part of something that should be considered. I don't know this, and it will not be up to me, but I suspect that most judges will not want to receive the audio recordings from a 5-day hearing. That's probably something that they don't have time to devote to 5 days of listening. They would rather get the transcripts typed out and have the parties each point them to the relevant portions. So there's things like that to consider. And then I think another really important point, which is a little less of a practice pointer, but something to sort of watch, is I think and I hope that over the next 3 to 5 years, the legislature may tweak the statute a little bit. Do some things like acknowledge that there's different risks to participants with domestic violence when there's a video conference based arbitration versus an in-person based arbitration, that maybe the timelines for reconsiderations and appeals should be different. Maybe even the decision on whether you can have binding arbitration on child-related arbitrations should be allowed. Lots of things could change, and perhaps the family law bar will make those suggestions. So I would pay attention to not just this video, but over the next several years, what is actually in the statute.
Certainly. Well, thank you, Judge Rosen, for sharing your knowledge of the new Uniform Family Law Arbitration Act with us today. And as a practitioner, I look forward to how this law is going to guide our future arbitrations and how the courts are going to address some of the nuances not presently addressed that we've spoken about today, and that are kind of missing in that plain language of the law. So thank you so much.
Thanks for having me, Amanda. Always a pleasure to see you.
Yeah, you too.
Take care.
Thank you. Bye.